Welcome, everybody, to the Beverly Hills Bar Association's Bankruptcy Section program on winning at the Bankruptcy Appellate Panel, the do's and don'ts for success. We have a great panel of Judge Gary Spraker and the clerk of the BAP, Susan Spraul. They will be introduced by our moderator, Scott Bovitz, in just a moment. But first, let me take care of a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will be stored in the Beverly Hills Bar Association membership only community. Please take a moment to complete the survey that is included with your certificate. The program will be available in a couple of days at the Beverly Hills Bar Association on Demand website, and newest member benefits presented by Lawyers Mutual Insurance Company. So on to the program. Those that have been to our previous bankruptcy programs are well acquainted with Scott Bovitz. He has such a long resume that if no one showed up, I would just spend the entire hour telling you what a great guy he is. So instead of telling you about his work for the state bar, his expertise in bankruptcy, I thought I would tell you about his efforts as a songwriter. On his website, he has 660 songs, including one about the Bankruptcy Appellate Panel and bankruptcy judges. But with that, I'm going to let Scott take over at this point. If you have questions, enter them in the question and answer section. I will be moderating them, and at the end of the program, we'll take a few minutes to put the questions out. So now I'll turn the program over to Scott to introduce our speakers in detail.
I'm so happy that Judge Spraker and Bankruptcy Appellate Panel, Madam Clerk Susan Spraul, that's what we decided that her official title would be. We might just call her Susan at her request, but I'm so glad that you're here to join me. I remember the mysteries of bankruptcy appeals going back a long ways, and I was amused to see an amicus brief at a U.S. Supreme Court case just this week in the Bartenwerfer matter, which is going up on 5/23. And the amicus says, hey, that en banc decision of the BAP in Sachan versus Hawaii, that is the greatest thing since sliced bread. And I was the one who argued that. And I didn't win. The BAP decided the right way, but it was, in favor of my client. But every time, I'm just a guy in the gutter, every time we start thinking about appeals, since I don't do appeals constantly, I'm always trying to refresh myself about the blocking and tackling. And that's why, Judge Spraker, you're a member of our panel, tell us something fun about your life, a guy who ends up in Anchorage with this really cool job.
Well, not where I thought I would be. I am in heart a Floridian, so a little displaced. I am admitted to practice in the bars of Florida, Colorado, and Alaska. So I have a straight shot. I went to law school in Colorado, where I met my wife. And like many people that I've discovered that come to Alaska, I came for a 2-year stint that has been expanded to going on 32. So yeah. That's how you get here. A lot, as they say, a lot of imports in Alaska.
In the slides on page 3, I pulled out a bit of the local paper because bankruptcy judges are important enough to make the local paper up there. And it was talking about your appointment and so forth. But the immediately adjacent story was headlines: biologists kill grizzly bear, suspected in Stuck Again Heights break-ins. So I'm thinking if I'm pulling up a page, it's got guy appointed to the bankruptcy court versus grizzly bear burglar captured or killed, I mean, no one's going to read about that. So you just snuck on the bench somehow in connection
Well,
with it.
I think that's the difference between Alaska and what we call the outside, Scott, because
Outside.
for bear stories in Alaska, those are a dime a dozen. And a bankruptcy judge getting appointed in Alaska, that's once every 20 years. So really, that was the headline for that day.
Well said. Susan, may I call you Susan?
You may call me Susan,
Okay.
Scott. May I call you
Okay.
Scott?
You can call me anything you want to, but Scott is just fine in connection with that. I saw those pearls in last year's World Series. One of the players was wearing them and did very, very well, and I'm glad to know that they've resurrected. So how did you end up here with your cool job of running the BAP?
Yeah, somehow I managed to narrow myself into the smallest corner of a career as being a bankruptcy appellate specialist. I practiced bankruptcy law, primarily Chapter 11 debtor work in St. Louis, Missouri. After going to law school in North Carolina, I did not continue the Northwestern spiral that Judge Spraker took. However, I then ended up turning back south to get to Pasadena, much more tolerant climate for me. But I practiced bankruptcy law. Maybe it's because the very first Chapter 11 case that I was involved in and debtors counsel made it to the Supreme Court. I was destined to hit the bankruptcy appeals world as former debtors counsel for Hen House Interstate.
What the cluck? I think that your team is fantastic and your physical facility is fantastic and the job is fantastic. And on page 6 of our slides, we talked about the fact that you've got a clerk, 2 staff attorneys, other personnel who maintain the files. I don't think they're files anymore. It can't be files. It's all this magic stuff online, right?
All magic. We're actually down to 1 staff attorney due to our shrinking caseload, but we do still have, I'm an attorney and a staff attorney, and we process your electronic pleadings just as we used to process your paper pleadings.
Where you print them out, throw them in the back.
A lot less paper cuts.
And John Hayes is your clerk now, is he not?
He is a BAP law clerk for Judge Laura Taylor.
So you've got a professor of law hanging out in there as playing out as the clerk. I think that's a fantastic gig. Going back to page 5 of our slides, we have 6 people rather than 7. Judge Spraker, you're authorized to have 7 judges on the BAP, are you not?
I defer to the clerk.
We are, however, many years ago when the irreplaceable Barry Russell's term on the BAP expired, given the low caseload, they decided not to replace him and leave 1 BAP judgeship vacant. So hence we have the irreplaceable Barry Russell and only 6 BAP judges.
We have Judge Taylor, Judge Ferris, Judge Lafferty, Judge Brand, Judge Spraker, who's with us, Judge Gann, and then Madam Clerk, Susan, don't you rotate in a regular old normal bankruptcy judge once in a while to sit in?
We do. We try to give bankruptcy judges throughout the circuit, especially newer bankruptcy judges, the opportunity to sit pro tem with the BAP. We think it's a great learning experience for them to get to be a Monday morning quarterback on their day job. Our caseload has been relatively low, as have all bankruptcy courts lately. And with the Zoom experience, we've kind of prefer to give new judges the opportunity to actually sit in a room with their fellow judges. So we haven't done a lot of pro temping in the last year, but we will continue to do that, both as a learning experience and to help us out with workload when it goes up, which it will.
I mean, we all want the economy to do well, but bankruptcy lawyers are like people who make bullets during wars, right? And interest rate goes up another 3/4 of a point this week. Yes, we think, but no, that's wrong. That's wrong to think that way. The load is coming up. On the other hand, you think, well, maybe it's not so busy. Judge Spraker, I was reading one of Susan Spraul's notes in the back, and you issue maybe 100+ decisions a year, but the U.S. Supreme Court is issuing like 60 a year. So, how is it that you guys can do, twice as much, or an extra third again? I mean, is it the dartboard? You just don't spend that much time working on it? It can't be that.
No, I think it's a little selective process there. We get, if you get through the maze of filing a bankruptcy appeal and it is, designated to the BAP, we'll hear it. Some of them require a lot of work, some of them don't, but, we've, as Susan said, the BAP has handled a lot more capacity than we have. So that's not the problem. And there's ways, you kind of covered it. There's ways if we need to draw on some extra help. You can have pro tems come in, and then you kind of, there's a multiplier effect. So there's ways to handle influxes of cases and such.
And I'll note that we are a specialized court. Maybe that gives us advantage over those generalists in DC.
Well, there's, I think of it this way. I was talking to a colleague in the 11th Circuit. I said, you don't have a BAP. No, they have a BAP in about half of them, I think, Susan Spraul, right? So, are the statistics saying that where we have BAPs in the various jurisdictions that cases get handled quicker and more efficiently, at least in the bankruptcy area? Is that true? Can we say that?
We can absolutely say that. The answer is no one really tracks the statistics of bankruptcy appeals that go through district courts. So we can tell you how great we are, and they make it very difficult to go beyond that analysis.
We're going to talk about the opt-out process, right? This is a weird thing, but bankruptcy courts make a decision and then it goes up to the BAP unless somebody opts out. And there's actually a box to check on the notice of appeal on the form that says, I don't want it. I'm an appellant. I don't want it. And then you go to the district court somewhere, one of the judges, or you go up to the BAP and then the appellee can, in fact, make that decision. Sounds like apple to me. I never have understood that word at all, but they can go to the district court. And then the question is, why do you pick them? And of course, we have to be very cautious. Why do you pick a district judge? That's more like, no, you can't take the car on that date, and then you go and ask mom to see if you can do it. It's a different kind of thing. We'll get to that. On slide 4, Susan Spraul, you've done a fantastic job of all sorts of stuff that shows up to help people who don't do a lot of appeals, bankruptcy lawyers. Can a regular bankruptcy lawyer handle an appeal by looking at your site and looking at the federal rules that deal with appeals, do you think, because of what you give them?
Well, given the number of phone calls we get, I would say they actually need to also call our office, but no, that's a unique thing about our caseload. We do have some attorneys who regularly file bankruptcy appeals, but for a lot of attorneys, one appeal in their career is it, or one every so often. So it as you mentioned earlier, there's always a need for a refresher. We provide a Litigants Manual, which sets forth, these are the processes. We do have people that we never hear from. They read the rules, they read our Litigants Manual, they file their appropriate pleadings at the appropriate court and get the matter fully briefed, and boom, it's set for hearing. So we do try to provide that. We also get a lot of phone calls, and we are the one court that still answers our phone and answers people's questions in this day and age. Perhaps that's a result of also being one of the only optional courts in the world, but we do still answer our phone, and we're happy to answer those questions.
I do think that's kind of a wonderful thing, and it's great. And of course, you don't pass along the message, Judge Spraker, you made a terrible decision, blah blah blah. So make sure you don't mess it up this time. You don't pass those along, right?
Well,
No, we have a separate venting counseling call. Yeah, we put on our counselor hat and let people vent. That's completely separate, yes.
Susan Spraul, do you actually have a real library too?
The Ninth Circuit has a lovely library in this building, and this is where the Ninth Circuit has chosen to locate its bankruptcy library.
Are you in Pasadena, 125 South Grand? The other 125 South Grand, not downtown LA. People go down there in Bunker Hill looking for it. It's not there. You're in Pasadena in like a residential area.
We are in the beautiful former resort hotel turned World War II rehab hospital turned now Ninth Circuit Court of Appeals. Beautiful building on a tree-lined street of mansions, yes.
It's gorgeous. Judge Spraker, you echo that, don't you?
oh, absolutely. Yeah, it is you know, you look at your phone to make sure you're in the right place when you go there the first time.
Susan Spraul, across the way, there's a parking lot, but it says only official business. Don't even think about parking here. Can I, just a lowly lawyer, park in that lot?
You're here for official business with the BAP, you absolutely can, with one caveat. You cannot park there for the Rose Parade. They fence it off.
Well, I think for the Rose Parade that Judge Spraker is not, he might be here for the Rose Parade, but he's not working on that. I did check on Zillow. It does list your building for, not for sale, but at $1,175,000. And I would be very happy to put together a group of bankruptcy lawyers to buy that building for that, because it's huge and wonderful. I'm intentionally not putting up our slides because I think we're going to let the folks take their slides and read what they want. And we're not reading the slides. But on slide 9, there are rules of the United States Bankruptcy Appellate Panel of the Ninth Circuit. Clerk Spraul, I don't understand why you need separate rules in connection with that, because, you know, we got the federal rules of bankruptcy procedure that have 8,000 and so forth that talk about that. And, you know, I'm not going to talk about any particular rule, but there's a bunch of them. Why do we need separate rules?
Quite frankly, the BAP rules predated most of the modifications to the federal rules of bankruptcy procedure. So we covered more than they did before they joined us.
On slide 10, you mentioned something called the Litigants Manual, which Judge Spraker would never ever look at, but which I think is the Bible. I don't use that phrase very easily for somebody who's, okay, I'm a bankruptcy lawyer, but can I do this appeal to the BAP? It tells me really almost everything with cases that I can cite to that I'm pretty sure the judges on the BAP will say, well, yeah, I know that case, that's okay. How did that come about? Did you do that, or is it a history thing?
That is a beautiful product that started years before I got to the BAP and was the work of many former BAP law clerks that has been maintained and updated through the year with the help of staff attorneys and a lot of the law clerks who work for the BAP judges.
It's real simple. Judge Spraker, I don't suppose I can cite the Litigants Manual to you, but it tells me, don't forget, Bovitz, to say this. So I write the this down in my brief, and you get it. And then it helps you, right? At least we get the stuff in order before you knock it down. On slide 11, we're reminded that what I just mentioned, the Federal Rules of Bankruptcy Procedure really tell you what you need to know, but it's kind of confusing because, you know, I show up in Pasadena to file my notice of appeal, and, you know, somehow this first part of the program, Judge Spraker, of course, is Susan Spraul telling us how we muck it up before we ever get to you. But that's not right?
We prefer that you file your notice of appeal at the bankruptcy court where it is to be filed. I will tell you there is a provision that says if you accidentally file your notice of appeal with the BAP, the district court, or the Court of Appeals, we can stamp it and forward it to the correct court. But it's much easier for me if you just send it to that court originally rather than to me to then send to them, for them to then send it back to me.
On slide 13, I remember the olden days. This is, you know, because I'm an old guy. Good. I remember we used to have to print the briefs and such, and they were different colors, and it was really cute. I can imagine, how Judge Spraker would sort out the colors of this and that. On slide 14, we point out something real important, and that's what you just said, Clerk Spraul, which is, hey, the stuff comes in through CMECF, the same thing we're used to. But gosh darn it, when I go to the bankruptcy court and I'm logged in as a bankruptcy court person, well, yeah, I can file my notice of appeal with the bankruptcy court because I have that there, right? But when I get around to doing my beautiful, exactly 35-page brief, that I'm sending to Judge Spraker because I want him to know that by writing more words, it must be a more weighty brief, that I need to have a different sign-in? Don't tell me that people actually call you on the last day saying I can't log in and file my brief because I only have my bankruptcy login number, right?
Regularly. Often after we've had emails at 11 o'clock at night. I can assure you, we do not have with our staff of, it's going to be soon 4 people, around the clock email monitoring. We are a different court. You need to go to PACER. If you are not a BAP ECF filer, you add an additional court, you add the BAP. We are a next generation ECF court. Now the bankruptcy court here is next generation. So you have the right account, you just need to add the BAP. I will say we were with the Ninth Circuit, the second court to switch to next gen. So we did have a problem for a while where you had to have 2 versions of ECF filing accounts between the bankruptcy court and here. But now, at least it's the same. But please go on to PACER, click the I want to add BAP button. It has to be processed by the Ninth Circuit Court of Appeals personnel. I get 0 funding for IT and for services. The Ninth Circuit staff will monitor and approve those for us. We're not necessarily going to be the highest priority for the Ninth Circuit IT department if, say, there is a circuit judge that needs the use of that IT staff department. So we ask you to please do it. Please register early.
Okay, so the magic here is this. Before you needed different numbers, now you got one number, but you have to have pre-logged in to link the courts. So if you want to do something in the Ninth Circuit, you want to do something at the BAP, you want to do something Central District Court, you want to do something at Central District Bankruptcy Court, that could all be one number, but you got to go to PACER and CMECF, I don't know, just that blob out there and log in. And you need to do it before the last day, because sending something to Susan Spraul at the last minute is not going to get your brief in, right?
I have no authority to approve your registration. All I can do is ask the circuit to do it for you. So please do it ahead of time.
But thank goodness my notice of appeal with the copy of the order or judgment being appealed from, my designation of record, you guys call it a DOR. That's so cool. That's like an Army thing, okay? And all that stuff, I can file it down below. So I am not even thinking about that I'm going to have a problem coming to the BAP until I got my big fat brief and I'm on the last day, right? And that's not the world's greatest thing. Judge Spraker, do you accept things called notices of unavailability for oral argument? That's in state court stuff. That's not federal stuff, is it?
Fortunately, I don't have to accept anything because Madam Clerk and her staff is on the job, and we get that information via her. So, as you'll hear, there's a lot that goes on before we become active.
We're already hearing that. We pay the filing fee. I don't know where that goes, but I know that CMECF takes my credit card, and I do that. And I know the first question that I have when I'm filing it, going back to my box, is district court? Mystery meat, we don't know which district judge is going to get it. Probably was a criminal, person, not criminal person, but someone who dealt with criminal law, or someone where I've got bankruptcy wonks who love the minutia of, oh, there's a hanging paragraph and, this kind of stuff. So which do I pick? Judge Spraker, you're going to say pick the BAP, of course, aren't you?
Every time, of course. We would appreciate it greatly, yes.
I think sometimes I might not pick the BAP if I'm pretty sure you guys are going to slam me down because my appeal is crappy, right? So I have I have an incrementally better chance with the uncertainty of a district judge who might think, well, that's not fair. Maybe there's a little bit, not the same level of respect that you all give to your bankruptcy brothers and sisters who are the judges down there. Maybe the district court judge is curmudgeon-y and 97 years old, and maybe I get some. Should I be thinking like that, or should I be thinking, is there a strategy here?
There's always a strategy. The question is how correct is that strategy? Because I have certainly heard the other way, that in popular parlance and thought in bankruptcy communities, that sometimes you want to go to district court because they don't deal with bankruptcy that much, and there's a deference given to the experts that may not be given in the BAP, because we're all experts. So it cuts both ways. Well, unfortunately, one of the things that I remember from my practice is time. As Susan said, sometimes litigants believe that a prompt decision is not necessarily in their interest, and maybe you want it in the district court for that reason. There's a lot of reasons. We have all heard on the BAP too that especially with pro ses, that they don't want to take it to the BAP because we're all part of the same team, and BAP isn't going to reverse its colleagues, and you can somewhat appreciate that lay view, but I think we've demonstrated time and again that that's not necessarily, and that's
You
just
do
not
it
true.
nicely. You do it nicely.
We try to do everything nicely. Sometimes some sharpness has to work its way in, but I think for all of us in the group that we have, civility is paramount, and we try to project that, not only in our writings, but also in oral argument. I mean, we want it to be professional and civil. And the bank and district courts are the same way overwhelmingly. Although, not necessarily going to get an oral argument over in district court. And, as this informal survey has been, recently kind of done. Rarely. I'm trying to be civil and again.
That's my experience. That's just
yes.
that's me.
And that has been confirmed with just an informal kind of survey of other people recently. It is rare to get oral argument on appeals to a district court.
I've had a district court appeal resolved in about 30 days, and I've had most bankruptcy appellate panel appeals resolved within, you estimate 10 months, I think, Susan Spraul, and that makes sense. That's probably right, certainly less than a year. And I've had some district court appeals that go, they're just gone, they're lost. A couple of years later, something comes out, and of course, by then, you really can't put Humpty Dumpty back together again. So it's interesting. Maybe if I'm looking for a delay and a holding pattern, maybe that's a part of actually reorganizing the case. I just need to take this and put it over here so it doesn't get finally resolved. Maybe that's a fair reason for that.
There's some other things, Scott, that really kind of need to be put into that calculation too. And one is, one of my colleagues says, it's always important to remember that the BAP is a functioning court. Has its own resources, its own procedures and stuff for this express purpose of bankruptcy appeals, whereas the district court has got plenty of other things to keep it busy. So what the lead up to the decision takes very different paths, because the staff attorneys and Susan examine a host of things prior to ever getting to the merits of the appeal, which I believe we'll talk about in a little bit. The district courts have to determine how they're going to handle that by themselves, but there's a rigorous review about finality, filing fees, prosecution, all of that is part and parcel of any appeal to the BAP. That is really at the discretion of the individual district judge handling an appeal in district court.
Well, wait. Slide 21. Yeah, I know that I can only appeal from final and final orders unless interlocutory order with some permission granted. But everything's final because the bankruptcy judge signed it and it's got an entered stamp on it, and that's good enough, right, Susan Spraul? You don't care about that, do you? You guys look at this before Judge Spraker gets to it?
We do. We try to flag anything that's interlocutory. And some people are proactive file a motion for leave with their notice of appeal, which gets filed at the bankruptcy court, but the BAP gets to rule on it, not the bankruptcy court.
It's Judge Spraker. It seems to me, I think the phrase that comes out of the most cases is flexible finality. Boy, that sure doesn't help me down here in the gutter.
It really doesn't.
I'm trying to figure out what's what, and some things are easy. Adversary proceeding, there's a judgment, motion to, modified, no, denied. Okay, I got something that's final, that's really easy. But in the bankruptcy case, there are 57 different little things going on. So how do you think about this for us? How can you help us think about that?
We think about it a lot. The problem is we don't really have any clear, bright lines that we can give you that's going to cover every situation, which is 200 and odd years into this. You would hope that something like finality would be a little clearer than it is, but you're going to be disappointed. Guess it's a year or two ago, the Supreme Court issued its decision in Ritson.
A good decision to read for everybody out there.
Highly recommended.
Mm-hmm.
It came down as we were finishing another decision in the BAP called Liu, which is kind of covering the same path. And there's a Ninth Circuit decision Judge Christen wrote, I'm drawing a blank on, which also covers it, and which all tells you is this is a continuing vital area of bankruptcy law that you need to be aware of and cautious about whenever you have a decision. And because as we're going to talk about, a lot of things that go on in bankruptcy appeals that can be covered up and put back together after the fact. But appealing is not one of those. Within the BAP, we have a published decision that if you miss the 14 days, that's jurisdictional and it's just going to be out of luck. So if you think it's not final and you're wrong, tremendous downside. If you file and it is a question of whether it's final, it's likely to get flagged by the BAP. You'll get a order from Susan saying that there's an issue, please respond. And then it'll go through a motion practice before us.
You have motions? Motions at the appellate court?
We've got motions. Yes, we do.
We've got motions.
Yes, we have motions. A lot of people, some very active, will want to move to dismiss the appeal because it is interlocutory, because there's lack of standing. All of the prudential, doctrines apply, and some will be threshed out prior to the merits. A lot of them get threshed out at the merits. And as we try, we are still not 100%, able to catch everything that is preliminary to the merits decision. Sometimes you'll have questions raised at oral argument saying, are you sure that we have jurisdiction? Is this really final? And that's sometimes the counsel has responded, yes, we've thought about that. It may not be in the brief, which is unfortunate, but at least they thought about it. Sometimes they don't, and that's problematic. So really the only takeaway that I can definitely give is please think about that. And if you're unsure, if you believe, after thinking about it, there really isn't a whole lot of downside to filing the appeal and having it deemed interlocutory. It just means you have to wait again. Whereas the downside to missing that is, litigation ending.
Right. If it's interlocutory, hey, wait a minute, I get to try it again.
And you can ask, as Susan said, you can say, hey, this is so important. Please hear it now.
And you can grant leave to do that on your own as well. In the middle of this, you have tremendous discretion with respect to that. The Liu case that we cited on slide 22, the leave to appeal from interlocutory orders, Susan Spraul's Litigants Manual on page 23 talks about that. So that's kind of, we get bogged down in that. Let's talk about a more practical thing. We have to designate the record. That's the DOR. In slide 24, Susan Spraul, why don't I just attach the dockets and say anything and everything that ever mentions the name in re debtor is a part of my record, because later I'll figure it out when I do my appendix.
Lazy, 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 and you're not helping yourself.
Oh, but I'm busy. I'm busy.
Well, I thought the purpose of the session today was winning in the BAP.
Well,
You know,
Judge, you're never going to read the designation of record. You're going to read my
Oh.
brief and appendix, aren't I?
well, there is no appendix now, right? There's the excerpt of record, which is
Right.
dependent upon your designation. But Susan's making an excellent point that needs serious attention here, which is put thought into it. We get these and we get them cold and we have to ramp up. They are not one-offs. There's a lot of them going on. We need to get into the record as easily as we can. And I'm amazed at the lack of thought, because it's easy to go, just say, put everything in. That's not helpful. And quite honestly, in the time that I've been on the BAP, the citations to the record are problematic, right? Because it's hard to figure out what you're referring to.
Sorry.
Go ahead.
I interrupted the judge. That's bad. Wait, I can do that during the program.
You can.
I put in a pin site to everything ever because I do not want to be like a deer in the headlights when Judge Spraker says, Mr. Bovitz, where is that fact the light was red in the record? And I go, I can look down and say, it's in my excerpt, page 114. At least I haven't missed the boat, right?
And that is tremendously helpful. And we will pick that up, but just make it consistent. What you see a lot sometimes is people just copying their pleadings below and putting it over. So you'll still see Exhibit A sometimes instead of the reference to it. And ease to flip back and forth is tremendously helpful. Also prioritizing what you are designating, giving us on the record. We don't need necessarily the certificates of service for everything. Being able to find the operative exhibit quickly is exceedingly important. The other fact that comes from the electronic world we live in now is that we have the availability and the ability to go back to the docket to get anything that we need. There really is no such thing as a designation of record, with one very important exception. We are not bound by what you give us. We can go back and look at the docket, look at the claims register, and you'll see a footnote in most of our opinions where we're exercising that right.
But
yes.
The judges are not required, unaided, to search the entire record below.
You never want to see that quote.
So if you would like them to see what you would like them to see, you should bring it to the judge's attention.
Wait, you've raised a great question, great problem, Judge Spraker, and Susan has emphasized this. We've got the designation of record and we can, do my little pin sites, but what about the stuff that's not on the docket, like Exhibit A, Exhibit B, Exhibit C at trial?
Yeah.
1 got admitted, 2 didn't. Maybe I didn't do a motion in limine to actually put something in the record about I'd really like this. How do I get those exhibits to you?
You do file them with the bankruptcy court and they'll be part of the record on appeal. There's 2 major areas here that are still excessively problematic. Trial exhibits is one of those. The pandemic has probably changed that a little bit because there's so many virtual matters being heard. I and a number of other judges, especially in the Ninth Circuit, have gone to filing exhibits on the record. We haven't really seen that percolate up to see if that addresses things, but not giving us a trial exhibit, which is central to the case, is just fatal to the appeal. And this goes to what we can do. I mean, we can backfill some of it if it's on the docket, but if it's a trial exhibit that's not anywhere on the docket, that will probably bring us to a stop very quickly. Tentative decisions still can be a problem in that regard. Right. If they are not incorporated into the final order, or if they're not found somewhere on the docket. So if you have a tentative decision and you're appealing, please make sure that is before us.
Judge,
the other thing, The other thing, Scott, just to mention quickly, is transcripts. Several jurisdictions have audio recordings attached to their into the docket. We do not search. We will not go listen to audio recordings. So give us a transcript of the proceeding. A lot of times that is essential. While it is not always going to result in a denial or dismissal of the case, it overwhelmingly hampers what we can glean. If we can't figure out what happened, then we can never say it's error. So that is essentially give us the transcripts though.
So Judge Sandra Klein, for one example, in the Central District of California, will issue written tentative rulings, and then if it becomes the ruling of the court, her clerk will upload it, say ruling of the judge, on this hearing. So now I've got docket entry 111, and I actually have it, and I can refer to that. Mm-hmm. But not every judge issues the tentative rulings, and not every judge keeps the same tentative right after argument, and so it's up to us, in anticipation of that appeal, to make sure that whatever the tentative ruling was that became the ruling gets in there. And it's up to me, right, Susan Spraul, to go to some person to get a transcript. I don't even understand. They're recording it. Why can't they do it?
And when you ask me that question, I tell you need to go to the bankruptcy court to get a transcript because I cannot get it for you.
So I go to the bankruptcy court and I click on the hearing, and I actually, in the Central District, we fill out a form and it goes up and we pick our reporter, and the reporter bills me some ridiculously low amount to transcribe this, and then it exists. Now I've got a transcript. And Susan Spraul, am I going to attach that whole transcript even though I really only care about where the judge made that big mistake at line 110? Shouldn't I just do little excerpts?
You should probably give us the whole transcript because it generally doesn't go well to take a small piece out of context, because the first thing the judge that's reviewing this appeal is going to want to know, and what was the rest of the sentence the judge said?
Yeah, I guess, I thought I got the exact part that I cared about.
But not at the beginning of that. If you just, quote it without the not, yeah, we do get that. And if you're the appellee in that situation, you might want to submit the entire transcript and say, they left out a few very important details.
Okay, so let's say I've got the whole designation of record done. We're not even at the important stuff yet, but okay, we got the whole designate. We're ready to go. And then, Susan Spraul, you're issuing something called a briefing order for the judges? Is that what happens?
Yes. Please send us a brief. Here's your deadlines. We need a brief. We need your excerpts, which are the documents that support the allegations you're making in your brief.
I call that the appendix, but that's because I'm so old, right? It's
appendix, excerpts of record. We take either name.
Okay, so you get a briefing order. We had that on slide 29. And now, no later than 11:59 p.m. on the day it's due. No. Never do that on the last day. If you do it the day before, at least I can bring it to Pasadena and manually file it because I didn't get my next gen stuff logged in, right?
If the building were open to the public, you could do that.
Okay, I have a on slide 30, an opening brief checklist, corporate disclosure statement. I guess that means, Judge Spraker, you don't want to be ruling on a case where you own shares of stock in, the other guy or whatever. A table of contents, well, that seems pretty easy. A statement of the basis of jurisdiction, well, everything in bankruptcy comes to you. 28 U.S.C. says so, right? Statement of issues presented. Oh, I know, Judge Spraker, this should be 14 things, right? I should have 14 problems. Is that right? Good practice?
We would hope that would not be right. Correct.
What are you looking for?
We're looking for specificity, which reflects some significant thought as to what issue was erroneously decided rather than those issues with which you may disagree. As that is the fundamental difference between matters on appeal and matters being heard for the first time in bankruptcy court.
Wow, that's a deep statement right there. But my client says the judge got it wrong because he or she ruled against me. Let's appeal, right? That's not enough for you?
That may well be a very short decision. Yes, that does not help us at all. And we are attuned to. I mean, one of the very interesting things about being on the BAP and being a bankruptcy judge is that you get to appreciate the difference between decisions and appeals. And it is something that we are mindful of all the time. There may be instances where we disagree with what was done, that we would not have done something, but that's not our role as appellate judges. We are looking for error, and that's why, the issues are important. The standards of review are critically important.
So there's some level, if you think criminal law, beyond a reasonable doubt, you think there has to be some level that you cross over before you turn something around, right?
Absolutely.
So you're looking for something that's more than, I might have decided it differently, but Judge so-and-so decided that, I'm going to let it stand. You have to decide, for example, the judge applied the wrong statute to the issue, some error of law. That would be something that you deal with, and you care about that because you care not only about this case, but telling the other bankruptcy courts, hey, look, y'all, this is not where you go for the rule of law that applies to this circumstance. Anyway, slide 30, we talk about all that, and then we ask for a short conclusion stating the precise relief sought. So can I just say, she done me wrong, referring to the lower court bankruptcy judge? Is that enough?
You can say it. That's not terribly helpful. We have had a surprising number of cases where we go and ask, what do you want us to do? And sometimes we get quizzical looks. But yeah, again, it's thinking about this in advance. Do you want us to send it back? Do you want us to reverse? Those are very different forms of relief that are available. And it really should be clear what you are asking us to do, because and sometimes that will have a significant impact on the review of the case.
And I can't stress this enough. And page 36 in your slides, the standard of review is the most important thing you as an appellate lawyer needs to think about. You would not, before you go into trial or file a motion and prosecute a motion, you are going to figure out what are the elements of this claim? How am I going to prove each of these elements? What is the burden of proof by which I need to prove these? That's your game plan. You wouldn't go into court without it, or you would not successfully go into court without that. Same thing on appeal. The most important thing is, what is the standard of review? What am I saying this judge did wrong? Yes, they done you wrong, and that's how your client feels. But if your client wants to succeed on appeal, they need to know, is this a factual question? Was this a he said, she said? The judge believed he and not she? That's a hard appeal. There has to be, clear evidence clear and convincing that the judge erred. And as an appellate court, always defer to the trial judge's determinations of credibility. They saw the witness, they listened to the witness. It's really, really important that you think about that from day one, because that's going to determine whether are you getting a do-over? In rare instances, yes. If it is a pure legal question, you're getting a new judge's opinion on it, and you are getting a do-over, but that is the small percentage. If you don't like the factual determinations, it was a matter of discretion. You don't like the way the judge ruled. You have to establish an abuse of discretion. So I really cannot, I've seen briefs where people say, well, the bankruptcy court erred and the bankruptcy court abused its discretion doing this. They're trying to cover their bases. They list all three. Look at that, think about it. It's the most important thing you can do.
Page 36 in the slides, we talk about clear error and de novo and the differences on that. On the And on slide 37, abuse of discretion, I want to talk about oral arguments for a second. Judge Spraker, are we still going to have 15 minutes aside?
You are.
And gosh, is the BAP, Susan Spraul, the only court that I know that almost always has oral argument?
If you want oral argument, we give you oral argument.
So my client has his or her day in court, right? Because I'm going to have the chance to come in. They're going to see Bovitz working his magic, at least from the back of my suit, okay? And how compelling I am if there was a live courtroom. Or they're going to be, you know, in one of these little boxes on that connection with that. How can I actually win an appeal in 15 minutes, Judge Spraker? I got 15 minutes. That's not very much time.
Right. And the easiest answer is to write a very compelling brief. Right. So this is the end of the process, is the oral argument.
You
yeah,
already know. I'm wasting my time with oral argument.
No. What you want to do is find out what concerns the panel has. And in that regard, by and large, the panels are fairly what, you know, we call hot. We will tell you. You know, it is very rare to get a totally quiet panel. So, but you need to listen very carefully. It's not so much the speech that you've given, but the answers to the questions that are you know, paramount. You need to convince us, take whatever we are saying and either explain why it's wrong, or in the rare instances why it's right. What we
just
are.
Just a minute, just break. I'll get to your question in a minute. I'm doing a presentation. Can't I finish?
You certainly may. That will not be terribly effective, but you may. You know, it's really a bad sign when the judges go quiet.
They're just letting me.
Not good. Yeah.
They're just thinking about lunch or something, right?
Well, yeah, they probably have decided that this is not helpful. You really want to, and again, this is all building up to this point. So you've thought about why you're appealing, what you're appealing, why you should win. You've gone and done your opening brief, you've gotten the response, and you've given your reply. By that time, you should know what the hardest questions are, and you should be prepared to answer those. You can't just, you know, stick your head in the sand and hope that you don't get the hard questions. It's usually those are the ones that we're struggling with. If it's a close appeal, you really need to pay attention to what the appellee has written and know why that is wrong, legally, factually, and why it does not affect the analysis of error. When you do that, it can be devastatingly effective. But, you know, it is, you know, what you were hoping is to have a mastery of the law and the facts and the arguments, know or predict what the weaknesses are that we will likely come at you, and then to be able to engage us into a conversation that you can use those questions to get us back to why your client has should win.
Are you going to be asking me easy questions so I can hit them out of the park for judge number 3, who's, you know, just not on point? You're just trying to. I'm going to have Bovitz demonstrate why I'm a winner. Has that happened?
It does happen, and those you would think are easy, but you are so geared to hear everything in an adversarial context. A number of litigants, lawyers will try to fight the lob, and they end up fouling it off instead of knocking out the home run. So, again, that active listening is critical. I mean, you really do need to be aware. It helps if you're the appellee, because you kind of have the gauge of the discussion before you step up. So, yeah, but yes, we certainly will ask a softball to try to get a point across.
Could I take 1 minute for oral argument and then reserve 14 minutes for reply so I can take the appellee's, you know, opportunity and work against them?
Yeah, you certainly can. I have never seen anybody go that extreme, but I've seen some recently say, you know, I want to reserve 10. We had one this morning that reserved half. 7 and a half.
It's important to remember that before you get going on your chart and these questions that you say, before we start, may it please the court, I'd like to reserve blank minutes for my time. So
Absolutely.
somebody will theoretically be watching the clock and say, well, Mr. Bovitz, you're at your 10-minute mark. We're going to thank you and let you come back for your 5 minutes. Is that how it works?
Generally, you know, in the heat of things, people forget to look at the clock. You know,
Yeah.
nowadays on the screen, there should be a clock, you know, a very 24 version of countdown.
Who wants to look at that? That's just going to distract me. I'm trying to hear what you say.
We'll try to let you know when you're in that zone. But, you know, it's easy to lose a bit of time here and there.
So slide 40. Go ahead.
If the judge is asking you a question, I recommend you finish answering the question and not say, oh, but my time is up. Although we did have an instance this morning where a judge said, you know what, why don't you stop now and think about that and reserve the rest of your time? So sometimes, again, they're actually helping you.
When we did the en banc on Sejan versus Ha, there wasn't any 15 minutes. The other guy went on. They went on with the other guy for, I don't know, an hour. And I'm thinking, where's that 15-minute clock? You know, and it's and I guess the answer is you guys have discretion to change that during oral argument, right? I don't have to. It's not a law.
Correct. We can, and you know, we've had very hot panels that will allow additional time. You know, I mean, we try to be aware of the context and such. We just got a chat question that I want to address because I think we're running close on the time here, and that was, do BAP panels confer before oral argument? Yes, we do. We actually have a preparation of a bench memo that's circulated by the lead judge, and then we meet before and have a fairly extensive discussion. Sometimes we'll meet a little bit before oral argument, just the judges, and discuss it, and then we'll have a conference afterwards. That is not necessarily typical of appellate courts. Like my understanding is the Ninth Circuit does not do that. They come in cold. But that's why when you appear, the standard introduction is, you know, here's a judge's, please know that we are prepared on this. We have talked about the case. We have discussed it. Meaning you don't have to repeat the introduction and the history of it. You can just get to the hardest part of it and tell us why you still win despite any concerns. We really are hopefully well read on that, and we have certainly talked about it, raised discussions. Does not mean that we have decided it. And there's plenty of cases where we want answers, that we are struggling with something, or we may just not have a decision or a feel of how we will go. And that's why oral argument is still critically important as a backstop. But again, it goes to, we are not asking these questions generally out of the blue. They are informed by our preparation.
So Susan Spraul and Judge Spraker and his co-panel judges have decided, do they come to you and say, we're going to issue an opinion, here it is, or a memorandum? What happens?
They say, here it is. I get an email, boom, here's our decision.
Then they've got 30 days to go to the Ninth Circuit where somehow they'll do better, or you issue a mandate back to the bankruptcy court. Is that what happens?
We do. Actually, the mandate comes before the 30 days are up.
Okay.
Timing issue, but yes, there's still 30 days to appeal to the circuit, but we issue it. We let the bankruptcy court know we've issued it.
Okay. We have some great slides that you can read, including the most important slide in my view is the cool statistics slide on page 48, which talks about percentages and all this kind of stuff. And I want you to do it. And at the end of our slides, we have the nice list of do's and don'ts that are kind of self-apparent in connection with this. Judge Spraker, can I ask you for final comments with respect to this, please?
Sure, thank you. Oral argument, we really haven't gotten into it, but I cannot stress, put the effort into it ahead. Be succinct. It shouldn't be wandering. Believe us when we say that we are prepared. So get straight to it. It shouldn't be scattered. You should go in with your strongest. Likely we understand your strongest. So I would advocate actually starting for your weakest and say, look, you're probably wondering about this. Let me tell you why it's not an issue, or let me know what you're worried about. But don't be afraid of the weakness. I mean, usually there's a way to distinguish. It's not applicable, something, the standard review. There's ways to do it. And if you've got a mastery of that, one, I think you're at a good place given hopefully the briefing. And two, I think you're ready for anything that's going to happen in an oral argument.
Susan Spraul, what are your final words of advice other than please read the gosh darn Litigants Manual cover to cover a couple times?
Don't wait till the last minute to register for BAP ECF. As a sales pitch, though, to use Mr. Bovitz's word, if you choose the BAP, you're dealing with bankruptcy wonks. You don't have to explain, and especially at argument or even in your brief, you don't have to explain. Well, you file a bankruptcy petition, and then this bankruptcy estate is formed. You can get right to the meat of it, which is why we do have oral arguments. They're interesting. You're going to get a good, prompt, thorough, well-reasoned decision with us. So come to the BAP.
And before I turn it over to Bob, I'd say when we're back to live oral argument, the coffee at the BAP is the best of any courthouse I've been to. So it's really good. Bob Aronoff, would you join us and make closing remarks, please?
I want to thank all of our speakers for a wonderful program. It was very interesting. I had one question that I wanted to ask. Is there any comparison of the rates of reversal between the BAP and district courts?
As far as BAP's reversing bankruptcy courts versus district courts reversing bankruptcy courts?
Right.
Mr. Bovitz, do you have a stat on that?
I don't. I do know that the reversal range at the BAP itself is 5 to 20%. So that is, if you're filing an appeal, you're not likely to win based on, you got 80% chance you're not going to make it for whatever reason in connection with that, and it could be less. So that's tough. And district court judges who don't understand this as well, I don't know if they're going to be as engaged as the BAP would be with respect to that. So I think the percentage has to be lower.
I will say typically, 90% affirmance rate is typical for appellate courts, with the possible exception of the experience of Ninth Circuit Court of Appeals to the Supreme Court of the United States, which we all know is a very low affirmance rate. However, again, district court, they don't really track those statistics, and we have to go through case by case. I can tell you that BAP decisions are typically well received at the Court of Appeals, and we do have a relatively low reversal rate at the Court of Appeals. We've had years without a single reversal, and former BAP Judge Randy Dunn, during his chief term, the BAP was not once reversed by the Ninth Circuit Court of Appeals. So he has that to hang on his cap. So, but an appeal is always an uphill battle, no matter what. So it's a long shot.
My understanding, and Susan, I think, correct me if I'm wrong, but generally speaking, statistics were shared recently that matters that come to the appeal to the BAP terminate more often than appeals taken to the district court, meaning that litigants are taking the second step in appealing to the Ninth Circuit more often from a district court decision than a BAP. Read into that what you will, but the numbers were a little surprising in that that there was a noticeable distinction between terminations of appeals.
They've historically, as we call it, the secondary appeal rate. You can appeal a bankruptcy decision to either the district court or the BAP. And those decisions then from either court go to the circuit. Historically, over, the last 15 years at least, typically twice as many cases are from the district court are then appealed to the circuit and the secondary level, then the BAP. So if we get 10% of our cases get second review, 20% of the district courts do, that's, and it's always been a higher district court number than BAP number.
Okay, I think that does it for our program. Again, thank you all for participating and doing a great job. Good materials, Scott. And our participants will get their certificate of attendance shortly.
Thank you very much.
Thank you.
Thanks for
everyone.
having us.
Thank you.